Well, let's get some legal analysis now, and we're joined by attorney Modidima Mannya. Mr. Mannya, good evening to you, and thank you for your time. A crucial question is asked by the judge during the arguments, and that is that what are the facts that negate against the arrest of the Speaker? Based on what you observed this afternoon, would you say that her lawyers did manage to make out a clear case on this?
Yes, good evening, Tony, and to your viewers. Yes and no. I think maybe to give a proper context, and probably this is what the judge will take into account. The NPA seemed to have tried to be nice and try to arrange with a person that they wanted to arrest to present himself or herself, and thereby opening a door for negotiations. If you listen to what the argument of the Speaker is she's not refusing to be arrested or to hand herself over. She's complaining about the logistics of the availability of her legal representative. Now, because the door has been opened for that negotiation, to some extent, then the NPA would have to be reasonable. But you must compare that with a situation where the police go and arrest Koli. They have a warrant for his arrest. They don't have to phone him and tell him, we are coming for you. They just go and pick him up. And I think that is one thing that starts to suggest that there are two systems that are being used, one that favors the well-to-do and that those that apply to the ordinary people. Yeah. So whether they made out a real case, I do not think so, because I do not think there would be a basis to prevent the law enforcement agency from arresting anybody. And I don't even think the issue is about that. The issue is about the dispute around when are you coming to hand yourself over.
And that's the point I want to pick up on, because her lawyers are saying there is a big stink in how the NPA has conducted itself here. They argue that there is a trial through the media, and this is the NPA accused of leaking information to the media. But they also point to the urgency matter. They're saying that what is the urgency in arresting her? Do they have a point?
Look, firstly, the issue about the trial by the media, we all know that Colin Gambi is one of the known news people in the country. Almost everybody knows you because you visit our homes every day. You are a subject of public interest. If anything were to happen, Goli, we would want to know what happened. So the Speaker is a high-profile person. She's a person of interest, public interest. So whether you like it or not, there will be some hunt for news about her. But I don't think you can go as far as saying the NPA is conducting a trial by the media. In the first place, she has not even been charged. There's no trial at all. And I think this thing of the trial by the media sometimes is a red herring, because we as the citizens have a right to know. The media has the right to disseminate information, and we know that you get information in more than one way. The second issue about why is it urgent to arrest her, why is it not urgent to arrest her, and if the law enforcement agencies are ready. This is not about urgency. It's about the state of readiness of the investigation. It means at this point, a warrant for her arrest can be issued, and she can be arrested, brought before court to initiate the process of a criminal trial.
I'll try and sum up what the state's counter was to Mapisa-Nqakula's legal team, and they're simply saying this, that this demonstrates, both on the part of the Speaker of Parliament, Mapisa-Nqakula, and her lawyers, that they are demonstrating that they're acting in bad faith. So I want to sum up our conversation with this question then, Mr. Mannya. It is now official. We know, based on what has come out in court, that Mapisa-Nqakula faces 12 counts of corruption involving an amount of 4 million rand. And of those 12 counts of corruption, one of them is money laundering. How weighty are these charges against her? And if convicted, could she be put away for a very long time?
Yes, Connie, corruption is a very serious offense, and I think you would know that any amount from 500,000 attracts a sanction of minimum of 15 years, the prescribed minimum sentence. So it is a very serious matter for the public. It's a serious matter for the National Prosecuting Authority, and it's a serious matter for the Speaker because, indeed, it may result in her being put away for a very long time. It is a serious matter for the NPA, and I don't think the NPA could gamble by dealing with such a serious matter in a clumsy manner of seeking to arrest a person when they don't have all the information, or at least the substantial information that they need to prefer a charge. It's a serious matter for the public because the Speaker is the leader of one of the arms of the state. Although the charges don't relate to her position as a Speaker, but as a member of the National Executive, she still remains a very serious functionary of the state. And we should be concerned that instead of maybe doing our work, as it is alleged, she has been being self-employed. So it's a very serious matter in that context.
Modidima Mannya, let me thank you very much for your time. That's attorney Modidima Mannya giving us some legal analysis on the arguments that you would have watched this afternoon.